Please, Your Lordship. Your Lordship, I beg to make mention of item 2. If this matter can be passed over to Wednesday, Your Lordship.
Item 2.
Item 2, Your Lordship.
Yes, Mr.
Fine, no objection.
This was only a part heard matter, isn't it?
Lordship, Lordship. The council is having some difficulty today, Your Lordship. It'll come on Wednesday. It's just fine.
Not on Wednesday. 1 week. On prayer made by the petitioner, this is matter up to 1 week.
Much obliged, Lordship.
May I be pleased, Your Lordship? Praying for 1 week's time in item number 3, Your Lordship. We'll be filing the objection in the course of the day. Let it come up after 1 week, Your Honor.
What? Objection to their...
Yes, Your Honor. We'll be filing in the course of the day, Your Honor.
You said you filed an application for amendment of the prayer.
Seeking, Lordship, amendment of the prayer portion.
Any corresponding vermins?
Lordship, it's there.
But why would you?
Pardon, Your Honor?
Why would you oppose that? Mr. Shulai, you're not...
Lordship, so far the state is concerned, so far the amendment, Your Lordship, because it is already there in the pleading. In fact, there is no requirement of filing that prayer for amendment of the relief, Your Lordship, because it is already there in the pleading. Because Lordship will have to consider whether the CM of Sarah has the power to collect toll or not. And then another point is whether that route on which the district council had authorized the CM of Sarah to collect the toll, whether that belongs to the CM of Sarah or it is a PWD road. So far the state is concerned, we filed the affidavit that road is not within our jurisdiction, Your Lordship. And please, Your Lordship, during the course, since they have asked for time, Your Lordship, I will not.
That's already the pleading. Then it must have been reflected in your counter affidavit.
It is already there in the pleading, Your Lordship.
So where is the scope for responding?
Let it come up after 1 week, Your Honor. As it is my senior also is not keeping well, he'll be there.
Because, Your Lordship, the contention of the writ petition is that the CM of Sarah doesn't have the authority to collect toll. So because there is a because of the notification issued by the Custom Department of the Government of India, it is already there. I don't know why they have filed that.
Lordship, we had filed a miscellaneous application seeking amendment of the prayer because there were certain arguments from the other side, Lordship, that the matter has become infructuous in terms of our prayer. Lordship.
Since they have asked for adjournment, Lordship, I am not opposed to that prayer, Lordship.
Mr. Leonard, have you met Leonard Counsel for the respondent number 6 as sought for accommodation on the ground that the Leonard conducting counsel is Mr. S.P. Amanta, and senior conducting counsel Mr. S.P. Amanta is not keeping well. It is also submitted that the Learned Counsel has further submitted that this respondent would file the response to the miscellaneous application filed by the petitioner seeking amendment of the prayer in course of the day. Accordingly, as prayed for, this is matter to 1 week.
All right, Lord.
Highly obliged, Lordship.
Daily list item number 1.
What is required here?
My lord, respondents had finished their submissions, I just had 3 very quick responses, my lord, by way of counter to their submissions, my lord. They had made extensive submissions over two or three dates, but I will not be responding to each and every contention. 3 major contentions which were advanced by them. I'll respond with lordship's submission very quickly. I won't take more than 10 minutes, my lord.
Yes.
The first aspect, my lord, is regarding a question that had fallen from my lord as to whether the 1923 lease deed, that is my lease deed, is it a continuation of the 1914 lease deed, which is their lease deed with some other person. The answer given by the respondents, whenever lordship had queried, was that yes, 1923 is a continuation of the 1914 lease deed. Factually, my lord,
With that variation.
With the slight variation of the area. In 1914 it was 16 acres. In 1923 it's 10 acres. Their contention is it is the same lease deed, just with modification of the area. But on the materials on record show that this is not correct, my lord. This is not correct. If lordship allows me to take lordship to page 116
Paperbook.
of the paper book, my lord. Page 116 is a part of the judgment rendered by the court of first instance, that is the suit court.
Yes.
Para 10 of this judgment, my lord, at page 116. I'll quickly read, my lord. Issue number 3, PW Shri so-and-so on his deposition on affidavit stated that the lease deed dated 2010-1914, which is Exhibit A, is not related to the plaintiff's club in any manner, and he has reiterated in his cross-examination that the Shillong Club was incorporated as a limited company and registered under the Companies Act only on so-and-so. This court also perused the Exhibit A, the lease deed dated 2010-1914, and found that this lease deed was between the predecessor in interest of the defendant and the secretary to the Shillong Sports Club, and not the Shillong Club. So it was with that 1914 lease deed was with some other person. I'll continue, my lord. This court has also perused Annexure 1 and also perused Papermark A, which is the lease deed between the predecessor in interest of the defendant and the plaintiff club for an area of 10.19 acres of land. After perusing both the lease deed dated so-and-so, dated 2010-1914, which is Exhibit A, and lease deed dated, it should be the 1923, which is Annexure 1 and Papermark A, this court found that the lease deed dated 2010-1914 is not between the plaintiff club and the defendant, but the lease deed dated 23-1923 is the lease deed between the plaintiff club and the defendant for an area of 10.19 acres. So there is no question of the 6 acres of land situated at the south of the golf club being reverted back to the defendant since 1923. So very clear finding of fact. Finding of fact which has not been challenged by them by way of a cross appeal or anything of that sort. As on date, this finding of fact remains, my lord. Finding of fact being, number 1, that 1914 lease deed was between them, respondents, and some other entity, not with me. Number 2, that there is no question that in 1923 I returned back 6 acres to them. Finding of fact, unassailed finding of fact, my lord. First aspect. So it is not correct, my lord. I have to say it is not correct to say that 1923 lease deed is a continuation of the 1914 lease deed. First aspect. Second aspect, my lord, and this is this is quite important. Second aspect is regarding the location of that 6 acres which they are laying claim on. Lordship would have noticed repeatedly through the pleadings and even in the judgment of the first court, the assertion was that 6 acres is located to the south of my 10.19 acres. Now, Lordship will kindly look at whether that is possible or whether that is true also. In this connection, my lord, if lordship looks at page 14 of the paper book, 1-4.
Yes.
Page 14 is the 1923 lease deed, my lease deed.
Yes.
Now, if lordship looks at the schedule of the 10.19 acres, east family poor land of so-and-so, north family land of so-and-so, west the lesser's own clan land, south old polo ground. Now, their contention is that the 6 acres, which apparently allegedly was returned to them in 1923, is to the south of my portion. South of my portion is old polo ground. It is not family. If lordship kindly sees the distinction, west it says the lessor's own land. If south is where the 6 acres is located, then it should have also said lessor's own land, but it says old polo ground. Just for clarity, my lord, if I'm allowed to direct lordship's attention to this compilation which had been filed earlier, my lord. Just for clarity, my lord. In this compilation, if lordship looks at page 52,
The map.
Map, my lord. Now, this map, my lord, is not on record in the sense it's not been exhibited by any party or relied on by any party, but just for clarity, just for the sake of convenience, if I'm allowed to direct lordship's attention to this map.
Yes.
If lordship looks at the map, lordship will see the south, as per the map, is on the bottom of the page. Right on the top left-hand corner, my lord, there is a compass.
Yes, yes.
So south is towards the bottom of the page, my lord. The bottom of the page, lordship will see what is there. Interstate bus stand. Interstate bus stand is there, my lord. Those days, 1923, there was no interstate bus stand. That used to be the old polo ground, my lord. That used to be the old polo ground. So
where there's that the parking lot.
The parking
now.
lot. The parking now, my lord. Now that is known as the interstate bus stand now. Tourist buses stand there.
Earlier it was.
After the ISBT has come, it stopped, I think. But in any event, the point being, my lord, the south of my land, as per the schedule, is the old polo ground. This map clearly shows that my land extends right to the bottom. Right to the bottom it extends. Old polo ground is where now the interstate bus stand is standing. So therefore, the location of the 6 acres is not clear. Their repeated contention is 6 acres lies to the south of my land. Number one, as per the schedule, what is to the south of my land? It is not the lessor's own land. It is old polo ground. Compared with, if that is read along, if that is compared with this map, it is very clear that my land extends right to the edge, because after that the old polo ground starts, my lord. So this, my lord, was the second aspect, the location of the 6 acres. The location of the 6 acres, their stand being that it is to the south of my property. The materials on record, the 1923 lease deed read along with that map shows very clearly that the south of my property is old polo ground. It is not the lessor's own land. Schedule would have reflected that, my lord. Number two.
So it means that the southern portion of your land is adjacent to the polo ground.
Is adjacent to the, now what is the bus stand? The road, my lord. From the road, starting from there, the jungle area, the shrub area, that is my land, my lord. That is the 90. That is the 10. That's where the 10.19 acres starts from, my lord. That's where the 10.19 acres starts.
Even now. If I mean we go by, is just personal knowledge.
My lord.
The land is inhabited. It's a private land. Some houses of private person?
No. If Lordship jogs Lordship's memory, there are certain shops, etc. Restaurant, Marine restaurant, etc. Marine and all is there. The wooded area starts from the side of those restaurants and goes up to the clubhouse. So that is where my land starts from. If Lordship again looks at the map, Lordship will see.
I could visualize that.
Yes, my lord. Yes, my lord. So my land starts adjacent to those shops. Whose land is that? I cannot say. But my land starts from the edge of the road up to the clubhouse. 10.19 acres has to be measured from there. So point being, my lord, 6 acres, which they say is to the south of my land. South of my land is the old polo ground, used to be the old polo ground, currently the bus stand, my lord. So location of 6 acres, not clear at all, my lord. And in any event, finding of the suit court, not challenged till today, that there is no question, these are the exact words of the suit court, there is no question that 6 acres was returned to the defendant in 1923. And that finding is standing, it is not being challenged, my lord. The third aspect, my final submission for today, is regarding the question of law that was formulated on the first date by this Honorable Court. One of the questions of law, if Lordship kindly recalls, was whether the first appellate court could have granted relief to the respondents without there being any cross appeal being filed. There was no cross suit counterclaim filed in the suit court, nor was there any cross appeal filed. The question formulated by my lord was whether any relief could have been granted to the respondents in that circumstance. Their immediate answer to that is no relief has been granted. No relief has been granted. So therefore, this question of law, according to them, according to respondents, was incorrectly formulated and should not have been formulated, my lord. Again, my lord, the materials on record reveal that this is not so. If Lordship kindly looks at page 173 of the paper book. Page 173 is part of the impugned judgment of the first appellate court.
We have gone through all these.
We have, my lord, but in view of the contention that no relief has been granted to them, it's important for me to once again highlight that yes, indeed, relief has been granted.
Yes.
Para 89, my lord. 89, my lord.
89.
At page 173. Now, first at para 88, my lord, first appellate court makes a reference, if Lordship recalls, to some Assam Frontier Tracts regulation of 1880. Then makes a reference to some notification, which we still don't know which notification is this, of 1929. Subsequently, at para 89, what does first appellate court say? In view of the said notification noted above, the Transfer of Property Act 1882 is applicable only within the territorial jurisdiction of the Shillong Municipality and Cantonment. The Transfer of Property Act 1882 has not been declared to be in force outside the normal areas of Shillong at the time when the lease deed dated so-and-so was executed between the parties. The lease deed dated so-and-so is not a valid lease deed, as the Transfer of Property Act 1882 is not in force in territorial jurisdiction where the landed property is situated. Now, I'll just pause, my lord. The declaration we had sought from the suit court, first court, was that we are a lessee holding a lease deed dated 1923, and therefore consequently we should not be disturbed. The suit court, for reasons which are not tenable, dismissed my suit after finding that 1914 lease deed was with some other person, after finding that I did not return 6 acres to them. For untenable reasons, my suit was dismissed. Against that dismissal, I had filed an appeal. The first appellate's court duty would have been to examine the suit court's judgment and to say whether it is valid or invalid. Number one. Number two, there was no dispute, and there still is no dispute between the parties about the 1923 document, my lease deed. They are also saying that I am entitled to 10.19 acres. However, first appellate court, what does it do? Without anyone's asking, without any prayer being made in that respect, declares the entire lease deed as invalid. Now, if the entire lease deed of 1923 has been declared as invalid, the 6 acres which they have been claiming goes to them. Along with that, my entire 10.19 acres also goes back to them. Is that not a relief? If that is not to be considered as a relief, my lord, I am at a loss to say what exactly does a relief amount to. They ask for 6 acres.
What does the decree say about it?
Lordship, formal decree was never really prepared. The judgment was passed. Judgment says suit dismissed. That's all. Suit dismissed, and that is the only finding on grounds which are not tenable, my lord. If I can just spend 1 minute on those grounds also, it may be instructive for this honorable court to appreciate. They received relief even from the first court. Even after my suit was dismissed, while dismissing my suit, relief was granted to them. That becomes clear, my lord, page 117. Now, page 116, I have already taken, my lord, through page 116. The clear finding that 1914 lease deed was with some other person. 6 acres was never returned to them. That is at page 116, which lordship has already seen.
Para 10.
Para 10, which I've already read, my lord. Now, page 117, para 17, para 13, 13. If I'm allowed to read, my lord, very quickly. This court has perused Exhibit B, Exhibit C, Exhibit D, Exhibit E, Exhibit F, Exhibit I, Exhibit 1, Exhibit 2, Exhibit 3, Annexure 3A, Annexure 5, and Annexure 7, and found that the plaintiff club did not make any objection when the defendant allotted the land to the Darbar Snong so-and-so, Srimati Emily so-and-so, Srimati so-and-so, so-and-so, so-and-so. Lordship, just to explain this part, their contention in their WS, one of the contentions was that they have been issuing pattas to various people from time to time. Now, those pattas, according to them, are within the 6 acres, within the 6 acres which was returned to them in 1923. These pattas, the issuance of these pattas are sub judice at the moment. 5 different title suits have been filed for cancellation of these pattas. If indeed it is true that they have been issued by the respondents, etc., that matter is still sub judice. Now, what does the suit court say? If I'm allowed to point out the last line of this para 13. In fact, the defendant had allotted the land in the year 1991 to the Darbar Snong of Golfling Pinthon Mukhra, and the plaintiff's club has never raised any objection to this, and according to section 115 of the Evidence Act, the plaintiffs are barred by estoppel. So that means, according to the suit court, in this paragraph, we cannot challenge the issuance of the pattas. That issue is still sub judice. So with respect to the suit court was not...
Which came first? That suit or this?
This suit came first. Once they filed the WS and enclosed those pattas, then we realized that something has gone wrong. Then we filed the 5 different title suits. Those are still pending, my lord. Now, for the suit court to declare that we cannot challenge the issuance of the pattas and we are barred under section 115 of the Evidence Act, etc., suit court has virtually decided those title suits. In other words, given relief to the respondents in those title suits without there being any prayer, without there being any counterclaim, my lord. So, my lord, to answer the question whether relief has been granted to the respondents, very clearly, my lord, suit court also granted relief, and more importantly, appellate court also granted relief. Appellate court declared my entire 10.19 acres lease deed as invalid, whereas there was no dispute between the parties about that document, my lord. So, the question of law that was formulated, that whether appellate court can grant a relief to a party, to the respondent, in the absence of a counter cross appeal, has to be answered in the negative. It could not have been in a position, appellate court was not in a position to have granted any sort of relief, but nevertheless, illegally, it has gone ahead and granted that relief. So these were the 3 basic points. One was the 1914 and 1923 documents are completely different. There is no link between the two documents. Number two, the 6 acres, the location of the 6 acres is not identifiable. Till today, they have not been able to identify where, according to them, is the 6 acres. They say the southern portion of my property. Documents show southern portion of my property cannot be the 6 acres. It is government land. It used to be the polo ground. Now it is the bus stand. And number 3, granting of relief by appellate court could not have been done in the absence of a cross appeal. These were the 3 basic points. There are other points also which require responses, other points raised by the respondents. But for me to stand here and issue responses to each and every such point would be an onerous burden being imposed on this Honourable Court. If Lordship allows, parties will file written submissions, my Lord. That might assist.
Yeah, that, of course. Yes. And if it is, slightly more detailed.
Yes, my Lord, definitely.
Accompanied by authorities.
My Lord, definitely.
So, Mr.
Yes, we can go with that. Pleadings are very clear. We have to go by pleadings.
Heard Mr. S. Nindal, counsel for the appellant, who has concluded his response to the argument advanced by Mr. H.L. Sangasu, senior counsel for the respondents. On conclusion of the hearing, the parties have submitted that we be allowed to file written argument in this regard around 2 weeks. This is matter of 2 weeks.
Yes, obliged.
Item number 4.
Good morning, Lodge. So is it? Session is it? For me, Lodge.
Yes.
Lodge, I had filed this bill application before, so I'll just bring the court up to speed as to what this pertains to. There's an application filed for release of an accused person arrested in connection with a UAPA case in Nongpo. He was taken into custody on the 12th of March 2024 and has been in custody for more than 1 year, 5 months.
Yes.
Lordship, out of all the offences alleged of the commission of,
In custody for
more than 1 year, 5 months.
5 months.
Right. Charge sheet has been filed and is undergoing trial. Charges are yet to be framed, though, Your Lordship.
Charge sheet filed. Charges not framed.
Charges are yet to be framed. Your Lordship, before I start delving into the merits of the case, I must inform the court that one of the sections of this instant case falls under Chapter 6 or Chapter 4 of the UAP Act, thereby attracting the embargo under Section 43D. I'll just read it out, Your Lordship. I must before I start delving into the matter, because the other authorities which I'm relying on also deal with a similar kind of circumstance. So I'll just read it out. Right, Your Lordship. It's basically an embargo like we have under Section 37 of the NDPS Act. So Section 43D.
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 Yes.
I'll just take you to 43D, subclause 5. Subsection 5, sorry.
Yes.
I'll read. Notwithstanding anything contained in the code, no person accused of an offence punishable under chapters 4 and 6 of this act shall, if in custody, be released on his bond or on his own bond, unless the public prosecutor has been given an opportunity of being heard on the application for such release. Is it fine? Okay. The proviso says, provided that such person shall not be released on bail or on his own bond if the court, on a perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Al-hal there. Your Lordship, this particular individual on behalf of whom the bail has been preferred, he has preferred it himself this time, he is also facing trial under section 18 of the UAP Act, which falls under chapter 4, thereby attracting the embargo. Now the question is, despite of the application of this embargo, would he still be entitled to bail? He would be, Your Lordship, because of non-compliance of a statutory and a constitutional mandate, which is section 43B of the UAP Act. I'll take Your Honour's attention to section 43B. subsection 1.
Yes.
Any officer arresting a person under section 43A shall, as soon as may be, inform him of the grounds of such arrest. Full stop. So this is the constitutional statutory mandate which has been flouted. Now it finds its ground under Article 22 of the Constitution of India, which says grounds of arrest must be communicated to the accused person. Same has been reiterated here as a statutory provision under 43A of the UAP Act. Now, Your Lordship, as to how these grounds of arrest are to be communicated and from which state is it mandatory applicable from, this question was answered to by the Honorable Apex Court in Prabir Purkaista's case. Oh, I'm sorry, just hand over this as well.
This has not been reported.
It has been reported, Your Honor.
Where's the citation?
Once. The citation, if Your Honor may pardon me, I have not quoted it. It's 2024 8 SSC 254. 2024 8 SSC 254.
Yes.
So this particular judgment also deals with a UAPA case. Prabir Purkasta's judgment, Your Lordship. Now, two relevant questions were answered here as to how the grounds of arrest are to be communicated. It says it must be done in writing. And second, as to from which date is it mandatory applicable from, it says from the 3rd of October 2023. Now, Lordship, before actually starting reading from this, rather than reading from this, there's another High Court judgment which I have placed before Your Lordship. This is a Delhi High Court judgment. Now, why I would rather read from Your Lordship is because relevant paragraphs from this particular judgment, which deals with the UAP case, and judgments which came before it, which compelled the court to pass the judgment Prabir Purkasta's case, have been quoted in this Delhi High Court judgment. I'll start reading from this. It would be gainful for us to understand as to what led for such determination. I'll take you, Your Lordship, before we again commence reading, even this particular individual who was granted, well, the relief of release, he was also undergoing trial for an offence under Chapter 4. So was this particular individual, Prabir Purkasta, Chapter 4. All these cases, the embargoes had applied. So I'll take you to Chapter 15, paragraph 15, Your Lordship, which you'll find at page number 9 of the Delhi High Court judgment.
This is also not reported.
This one, no, Your Lordship. No, Your Lordship. Although the case number is there at the top. Para 15. We start reading from paragraph 15, which is at page number 9.
Yes.
Right. So the contention was the same, Your Lordship, in this case as well. The petitioners had argued that the grounds of arrest were not communicated in writing, and but the observations basically start from paragraph 15. I'll start reading. On the other hand, the NIA's principal contention are 15.1. that since the petitioners were arrested on the 13th of March 2024, there was no legal requirement for the NIA to have served upon the petitioners a ground of arrest in writing, but that in any event, at the time of the arrest, the grounds of arrest were explained to the petitioners orally, and that later the grounds of arrest were served upon the petitioners in writing as a part of the remand applications. And certain other objections were also quoted in the relevant paragraphs. And then from paragraph 17, Your Lordship, what it does is the High Court From paragraph 17, I've highlighted the relevant
Yes.
paragraphs, Your Lordship. From paragraph 17, what it does is it paraphrases judgments or paraphrases relevant portions of certain High Court, Supreme Court judgments which led. Okay. So paragraph 17, Your Lordship, the legal proposition on which the rival contention of the parties are based arise from the following precedents, the relevant portions of which have been extracted below. The first judgment cited in which the Honorable Apex Court dwelt upon the issue of whether the grounds of arrest are required to be communicated to an arrestee in writing was Pankaj Bansal's case. I'll just shift to the other page, Your Lordship, which I've highlighted, paragraph 42 of Pankaj Bansal's judgment. I'll start reading, Your Lordship.
Yes.
That being so, there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course and without exception. There are two primary reasons as to why this would be the advisable course of action to be followed as a matter of principle. Firstly, in the event such grounds of arrest are orally read out to the arrested person or read by such person without with nothing further, and this fact is disputed in a given case, it may boil down to the word of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. Non-compliance in this regard would entail release of the arrested person straight away as held in V. Senthilal Balaji's case. Paragraph 43, Your Lordship.
Yes.
The second reason as to why this would be the proper course to adopt is the constitutional objective underlying such information being given to the arrested person. Conveyance of this information is not only to apprise the arrested person of why she is being arrested, but also to enable such person to seek legal counsel and thereafter present a case before the court under section 45 to seek release on bail if she so chooses. We shift to the other page, Your Lordship. This is a highlighted point. Highlighted portion. The very purpose of this constitutional and statutory protection would be rendered nugatory by permitting the authorities concerned to merely read out or permit reading out of the grounds of arrest, irrespective of the length and detail, and claim due compliance with the constitutional requirement under Article 22(1) and the statutory mandate under Section 19(1) PMLA. Lordship, under the UAP Act, the statutory mandate is under 43B, which I just read. I'll read the other paragraph as well. On the above analysis, to give true meaning and purpose to the constitutional and the statutory mandate of Section 19(1) PMLA of informing the arrested person of the grounds of arrest, we hold that it would be necessary henceforth that a copy of such written grounds of arrest is furnished to the arrested person as a matter of course and without exception. In the case on hand, the admitted position is that the ED's investigating officer merely read out or permitted reading out of the grounds of arrest of the appellant and left it at that, which is also disputed by the appellants. As this form of communication is not found to be adequate to fulfill compliance with the mandate of Article 22(1) of the Constitution and 19(1) of the PMLA, we have no hesitation in holding that the arrest was not in keeping with the provisions of Section 19(1) PMLA. In effect, the arrests of the appellants and in consequence the remand to the custody of ED and thereafter the judicial custody cannot be sustained. Thereafter, Your Lordship, in paragraph 17.2, it quotes another Apex Court's judgment, which is Ram Kishore Arora. The citation is given at the bottom of the page, Your Lordship, 2024 7 SCC 599, at the very bottom. I'll start reading. The aforesaid view in Pankaj Bansal was followed by the Supreme Court in Ram Kishore Arora versus Directorate of Enforcement, which was yet again a case under Section 19 of the PMLA, in which the Supreme Court further dilated upon the legal necessity of furnishing a copy of the grounds of arrest to an arrestee in the following words. Lordship, will change the page, we'll go to the relevant paragraphs. I've only highlighted the relevant paragraphs. Lordship, when we turn the page, we come to a paragraph number 22. Although not highlighted, there is a certain portion of paragraph 22 which is underlined, if you can see it.
You're reading this 23?
Para 22, Your Lordship. Just above the
22.
highlighted portion, there's an underlined.
Yes, yes.
Let me read that as well, Your Lordship, although not highlighted. Therefore, in our opinion, the person arrested, if he is informed or made aware orally, about the grounds of arrest at the time of his arrest and is furnished a written communication about the grounds of arrest as soon as may be, that is as early as possible and without reasonable convenient and within reasonably convenient requisite time of 24 hours of his arrest, that would be sufficient compliance of not only Section 19 of the PMLA but also Article 22(1) of the Constitution of India. Para 23, Your Lordship. As discernible from the judgment in Pankaj Bansal's case, Also noticing the inconsistent practice being followed by the officers arresting the persons under Section 19 PMLA, directed to furnish the grounds of arrest in writing as a matter of course henceforth, meaning thereby from the date of pronouncement of the judgment. The very use of the word henceforth implied that the said requirement of furnishing grounds of arrest in writing to the arrested person as soon as after his arrest was not mandatory or obligatory till the date of the said judgment, referring to Pankaj Bansal's judgment. The next portion, Your Lordship. Hence, non-furnishing of grounds of arrest in writing till the date of pronouncement of the judgment in Pankaj Bansal could neither be held to be legal nor the action of the officer concerned in not furnishing the same in writing could be faulted with. It says, although yes, but only up to the passing of the judgment in Pankaj Bansal's case. And Pankaj Bansal's judgment, Your Lordship, was passed on the 3rd of October 2023.
So thereafter the judgment comes into force.
Absolutely. And after the 3rd of October 2023, in all arrests made, it becomes mandatory incumbent upon the arresting authority to furnish grounds of arrest in writing. Now, this matter was also dealt with in paragraphs 44 and 45 of Prabir Purkasta's judgment, which we are getting to now, Your Lordship. Now it quotes the Honorable Apex Court's judgment passed in Prabir Purkasta. We start reading from paragraph 17.3, Your Lordship. The after noted judgments were followed by another celebrated decision of the Supreme Court in Prabir Purkasta, which, however, was a case under Section 43B. Is it okay?
Yes, yes.
Okay, sorry. Which, however, was a case under Section 43B of the UAPA. And in that case, the Supreme Court articulated the parity as between Section 19 of PMLA and Section 43B of the UAPA, insofar as the necessity of furnishing grounds of arrest in writing is concerned, with the following significant observations. Paragraph 16. Upon a careful perusal of the statutory provisions reproduced supra, we find that there is no significant difference in the language employed in Section 19(1) PMLA and Section 43B(1) UAPA, which can persuade us to take a view that the interpretation of the phrase inform him of the grounds for such arrest made by this court in Pankaj Bansal should not be applied to an accused arrested under the provisions of the UAPA. Paragraph 17, Your Lordship. We find that the provisions regarding the communication of the grounds of arrest to a person arrested contained in Section 43B(1) of the UAPA is verbatim the same as that in Section 19(1) PMLA. The contention advanced by the learned ASG that there are some variations in the overall provisions contained in Section 19 PMLA and Section 43A and 43B of the UAPA could not have any impact on the statutory mandate requiring the arresting officer to inform the grounds of arrest to the person arrested under Section 43B(1) UAPA at the earliest, because, as stated above, the requirement to communicate the grounds of arrest is the same in both the statutes. As a matter of fact, both the provisions find their source in the constitutional safeguard provided under Article 22(1) of the Constitution of India. Hence, applying the golden rules of interpretation, the provisions which lay down a very important constitutional safeguard to a person arrested on charges of committing an offence either under the PMLA or under the UAPA have to be uniformly construed and applied. Para 18. We may note that the modified application of Section 167 CRPC is also common to both the statutes. Thus, we have no hesitation in holding that the interpretation of statutory mandate laid down by this court in Pankaj Bansal on the aspect of informing the arrested person the grounds of arrest in writing has to be applied pari passu, which means similarly, of course, Your Lordship, to a person arrested in a case registered under the provisions of the UAP. Further, Your Lordship, para 19. Resultantly, there is no doubt in the mind of the court that any person arrested for allegation of offences of commission of offences under the provisions of UAPA, or for that matter any other offence, has a fundamental and statutory right to be informed about the grounds of arrest in writing, and a copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without exception at the earliest. The purpose of informing to the arrested person the grounds of arrest is salutary and sacrosanct, inasmuch as this information would be the only effective means for the arrested person to consult his advocate, oppose the police custody, remand, and to seek bail. Any other interpretation would tantamount to diluting the sanctity of the fundamental right guaranteed in the Article 22 of the Constitution of India. Para 30, Your Lordship. I'm sorry it's a little detailed, but we must. So para 30 again. Furthermore, the provisions of Article 22(1) have also been interpreted by this court in Pankaj Bansal, laying down beyond the pale of doubt that the grounds of arrest must be communicated in writing to the person arrested of an offence at the earliest. Hence, the fervent plea of the ASG that there was no requirement under law to communicate the grounds of arrest in writing to the appellant accused is noted to be rejected. Para 37. The interpretation given by the learned single judge that the grounds of arrest were conveyed to the accused in writing via the arrest memo is unacceptable on the face of the record because the arrest memo does not indicate the grounds of arrest being incorporated in the said document. Column 9 of the arrest memo, which is being reproduced herein below, simply sets out the reasons for arrest which are formal in nature and can be generally attributed to any person arrested on accusation of an offence, whereas the grounds of arrest would be personal in nature and specific to the person arrested. So, if Your Honour recalls, Your Lordship, we have dealt with this matter before, and there was an objection raised by the respondents wherein they said the grounds of arrest were communicated to the accused through the arrest memo. Now let us peruse the arrest memo, Your Lordship. We'll just stop here, we'll get back to, but I believe here, at this juncture, it would be gainful just to refer to the arrest memo as well, which is at page 13 of the petition.
Page
13 of the petition, Your Lordship.
13.
One three. Yeah. So he's already there. Now, I remember the respondents taking us to paragraph 8, wherein it has been stated the arrested person, after being informed of the grounds of arrest and his legal rights, was taken into custody on the 12th of March. We'll stop there. Now, this interpretation, this particular contention has also been dealt with by the Honorable Apex Court through this paragraph 37, which I just read out, wherein it was held upon a perusal of the arrest memo. It can clearly be seen that the grounds of arrest were not incorporated onto the said document, which means the arrest memo. As such, their contention of having had even informed the accused of the grounds of arrest cannot be taken into consideration. Right, Ulad?
Yes.
Cannot be taken into consideration. And of course, let us not forget that it must be done in writing, Your Lordship. Now, if you read the arrest memo, what do we find, Your Lordship? If you flip the page over to page 14,
Yes.
okay. If you flip the page over to page 14, Lordship, we find that the grounds of arrest have not been incorporated on page 14 either. Neither does page 13, neither does page 14 show that the grounds of arrest were incorporated onto the said document, which is the arrest memo. Paragraph 8 merely mentions it was communicated, but in this judgment also it was clearly been stated, if it was not incorporated, how can it be assumed that it was ever communicated? However, let us not forget it must be done in writing. Then let us go to the next annexure, Your Lordship, which is in page 15.
Yes.
Page 15 is the remand report. Now, if we peruse the remand report as well, Your Lordship, we find that the grounds of arrest have not been incorporated onto the remand application either.
This is the first remand.
First remand. First remand. I'll just start referring to the relevant paragraphs. If Your Honor peruses the remand report, Your Honor will see the brief story of the case. Brief story of the case, correct? So it goes on, this entire page goes on about speaking about the brief story. The last paragraph, if Your Honor peruse it, starts with, on being examined, Damanba's detailed statement was recorded, etc., etc. Then we turn the page, Your Lordship, and we go to page 16. The next paragraph says, during the course of investigation, Damanba revealed the names of other co-accused persons who were involved in the instant case, and accordingly they were also arrested. And finally, the concluding paragraph, it states, therefore, I pray Your Honor to allow the arrested persons to be remanded to 10 days police custody. What can we conclude? We can easily, safely conclude that the grounds of arrest were not also incorporated onto the remand application. And finally, the last document which dealt with the first remand of the accused persons is annexure 4, which is at page 12. This is the very next page, Your Lordship, the very next page. Arrest memo, we have dealt with arrest memo. Okay, so this is the first remand order, Your Lordship.
Page 12?
No, this is page 17, the remand order. We have dealt with the arrest memo, we have dealt with the remand application, and finally we come to the first remand order, which is at
Remand
page
order.
12.
Yes.
Oh, sorry, which is at page 17. I beg your pardon, Your Lordship. And your order, as you can see from the date quoted in the column.
This is also this was the
First
order
remand.
first.
That is discernible from the date noted in the column, Your Lordship, which reads as 12th of March 2024, the date of arrest of the accused person. 12th of March 2024.
Yes.
Now, if we peruse the remand report, this also doesn't speak of grounds of arrest being communicated to the accused either in writing or even verbally. If I read the whole thing, Your Honor, it would just...
Not necessarily. You have stated your point.
Absolutely. So this contention was raised, hence I am actually bringing it up before they do, because I know this would come up as well. And we continue reading the judgment where we had stopped, Your Lordship. We had stopped at paragraph 37, where the Honorable Apex Court interpreted as to whether the respondent stating that it has been incorporated, it has been done through the arrest memo can be taken into consideration or not. It held no, because it doesn't infer that it was incorporated. So if it was never incorporated or formulated, how can it ever be assumed that it was communicated? We start reading for para 44 again, Your Lordship, the last paragraph of the page.
Yes.
It was the fervent contention of the learned ASJ that in Ram Kishore Arora, which I have already read, a two-judge bench of this court interpreted the judgment in Pankaj Bansal to be having a prospective effect. Very correct. To be having a prospective effect, and thus the ratio of Pankaj Bansal versus Union of India cannot come to the appellant's aid. Indisputably, the appellant herein was remanded to police custody on the 4th of October 2023, whereas the judgment in Pankaj Bansal was delivered on the 3rd of October 2023. On the 3rd of October 2023, merely on a conjunctural submission regarding the late uploading of the judgment, the learned ASJ cannot be permitted to argue that the ratio of Pankaj Bansal would not be applicable to the present case. Hence, the plea of Shri Raju, learned ASJ, that the judgment in Pankaj Bansal would not be applicable to the proceedings of remand made on 4th October 2023 is misconceived. We are of the firm opinion that once this court has interpreted the provisions of the statute in context of the constitutional scheme and has laid down that the grounds of arrest have to be conveyed to the accused in writing expeditiously, the said ratio becomes a law of the land binding on all the courts in the country by virtue of Article 141 of the Constitution of India. I'll hold the Your Lordship. So in this particular judgment, it was again contended by the respondents that this particular individual was arrested on the 4th of October 2023, a day after the passing of the judgment of Pankaj Bansal. Hence, it couldn't be applied. It was technically very difficult. Yet, the Honorable Apex Court held no. It would be applicable to remand proceedings made on the 4th of October 2023 as well, and onwards. Our accused was arrested on the 12th of March 2024. Hence, it would squarely be applicable to this case as well. I'll start reading the other para as well. Para 48. 48.
This Prabir Prokasa order was dated
15th May 2024. 15 May 2024.
May
2024.
24. You were arrested in October. It would cover it.
It will cover, because in this judgment as well, Prabir Pukasta's judgment was passed on the 15th of May 2024. Yet it held.
Oh, you were arrested in March.
I was arrested in the month of March, prior to the passing of the judgment of Pankaj Bansal. Prabir Purkasta. But in the relevant paragraphs which I just read out, Your Lordship, it has been held that it would also be applicable. The direction given of grounds of arrest to be furnished to the accused in writing is applicable from the 3rd of October 2023. And it would be...
that is only because of the... See, the issue raised here was because of the uploading of the judgment. It took time, perhaps a day or two.
No, Your Lordship. What had happened was, Prabir Purkasta was arrested on the 4th of October.
We're talking with this Pankaj Bansal.
Pankaj Bansal.
This observation here.
Yes, Your Lordship.
The observation that you have read just now.
Right, Your Lordship.
Is why he talks about the late uploading of the judgment.
That was
so that should not be taken as an excuse.
Of course, it should
because
not.
The dates are very marginal.
Of course.
Just one day or so.
Right.
3rd and 4th.
Right.
But here it's a question of months.
No, Your Lordship. Again, we forget. Pankaj Bansal's judgment, I'll just start quote. Pankaj Bansal's judgment was passed on the 3rd of October, it was passed on the 3rd of October 2023.
Yes.
Prabir Purkasta was arrested.
Don't confuse with the issue.
Right.
The point that is to be, quantified.
Right.
Is this. If you are drawing parallel as to the date of your arrest, vis-a-vis the application of Prabir Prokasta case, and then you see you take the illustration or the the example of the application of Pankaj Bansal case in this case.
Right.
Where here, what you have read just now, the difference is just 1 day.
1 day.
1 day. 3rd and 4th.
Absolutely, Your Lordship.
But the court says that would be negligible or marginal because of the fact that there was a late uploading of the judgment.
Right.
So that's it.
That's it.
But as far as Pravir Purkastar case is concerned, it was passed in October
15th of May 2024.
15 May. Sorry, 15 May. Your arrest was in
12th of March 2024.
So that's 2 months there.
Absolutely.
So it would, you would not have dreamt. You would not have dreamt of Pravir Purkastar when you were arrested.
No. I had to wait for this interpretation to come out, of course, Your Lordship. Because through this, it was very clear through paragraphs 44 and 45.
That's beside the point.
Of course.
We are talking about application of the authority.
No, I wouldn't. Because
but then the only thing, perhaps, the principle can be...
No, it is applied and it is still being unified. It is still being applied, Your Lordship, till date. This judgment of Pankaj Pravir Purkastar, it was taken to the apex court twice on reference. I'll continue reading.
It will be applicable to subsequent, cases or arrests made after October or made after May.
No, Lordship. Made after the 3rd of October 2023. It answers this very question in paragraph 44 and 45, which I just read. If I may be allowed to read it again. And we will have to also read the following paragraphs. Hence, I brought out this Delhi High Court's judgment. I'll read paragraph 44 again, Your Lordship. So, paragraph 44. What had happened, I'll just again quote. Pankaj Bansal's judgment was passed on the 3rd of October 2023, wherein the apex court held that it is mandatory for the arresting authority to furnish the grounds of arrest in writing. Now, Pravir Purkastar was arrested a day after the passing of the judgment in Pankaj Bansal on the 4th of October 2023. Now, when this hearing was on in the apex court,
this was the Ramkishore Arora.
Ramkishore Arora. Yes, Lordship.
This is the reference to Ramkishore Arora.
Yes, of course. Ramkishore Arora is why it's been quoted in paragraph.
Just one.
Right, Lordship.
Yes, this is Thokom Shamjay Singh.
Right, Your Lordship.
Okay, sorry.
It's alright. Because we are reading the High Court judgment. Why? Because it was very categorically brought out in a chronological order as to what led to the passing of the judgment in Pankaj Pravir Purkastar's case, in a UAP case. That is why I was reading all these judgments. So what happened again, Your Lordship, we'll just get back. I know it becomes a little technical because of the dates. So on the 3rd of October 2023, the Honorable Apex Court passes a judgment in Pankaj Bansal's case, which is a case under the PMLA. It says the grounds of arrest must be furnished to accused persons in writing. Then comes Ramkishore Arora's case, in which the Honorable Apex Court holds that this direction of furnishing grounds of arrest in writing to the accused is applicable from the passing of the judgment in Pankaj Bansal's case, which is from the 3rd of October 2023. Full stop. That's the only interpretation it makes. Then comes Pravir Purkastar's case, a case under the UAP. This particular individual, Mr. Pravir Purkastar, was arrested on the 4th of October 2023, a day after the passing of the judgment in Pankaj Bansal's case.
Okay.
So when the hearing was on, a plea was raised by the council, by the government, of course, and it was said that Sir Pravir Purkastar's judgment, Pankaj Bansal's judgment was passed on the 3rd of October 2023. This accused with whom we are dealing was arrested a day after, on the 4th of October 2023, and it was impossible for us to know what the direction was because of the late uploading of the order. Yet, despite of that fact, Your Lordship, the Honorable Apex Court in this particular judgment held in paragraph 44, let me read it again. Now, this paragraph 44 of Pravir Purkastar's case.
Okay, this Pravir Purkastar.
Yes, Your Lordship. It was the fervent contention of the learned ASJ that in Ramkishore Arora, a two-judge bench of this court interpreted the judgment in Pankaj Bansal to be having a prospective effect, and thus the ratio of Pankaj Bansal cannot come to the aid of the appellant. Indisputably, the appellant herein was remanded to police custody on the 4th of October 2023, whereas the judgment in Pankaj Bansal was delivered on 3rd of October 2023, merely on a conjunctural submission regarding the late uploading of the judgment the learned ASG cannot be permitted to argue that the ratio of Pankaj Bansal would not apply to the present case. Hence, the plea of Shri Raju, learned ASJ, that the judgment in Pankaj Bansal versus Union of India would not apply to proceedings of remand made on 4th October 2023 is misconceived. So basically what it says is, from the date of the passing of the judgment, again from the 3rd of October 2023, it is mandatory and incumbent upon the arresting authority to furnish grounds of arrest in writing. And this is applicable to remand proceedings made from the 4th of October 2023 onwards. Hence, it covers this particular case as well, because this individual was also arrested after the interpretation made by Prabir Purkastas, after the judgment made in Pankaj Bansal's case. This individual was arrested on the 12th of March 2024. And in Prabir Purkastas' judgment itself, it said it would apply to remand proceedings made after 4th of October 2023. Not Yes. We'll read para 45 again. We are of the firm opinion that once this court has interpreted the provision of the statute in context of the constitutional scheme and has laid down the grounds of arrest have to be conveyed to the accused in writing expeditiously, the state ratio becomes the law of the land, binding on all the courts in the country by virtue of Article 141 of the Constitution of India. I'll take you to paragraph 48. I'll just take you to the highlighted portion, the last portion, Your Lordship, the fourth last line of this particular paragraph. Yes. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he is being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with reasons of arrest which are general in nature. As a result, the appellant is entitled to a direction of release from custody by applying the ratio of the judgment rendered by this court in Pankaj Bansal. So basically, it was also interpreted by the Honorable Apex Court in Pankaj Bansal's case, number 1, that is applicable to UAP cases. 2, that what means by furnishing of grounds of arrest is that it must be done in writing. And number 3, that it is applicable to remand proceedings made from the 4th of October 2023 onwards. Hence, also applicable to this case. If we are clear on that point, Lordship. Yes, sir. Now we are clear on that point. Lordship, I'll take you to paragraph 19. If there was to remain any doubt about the sacrosanctity attached to furnishing the grounds of arrest in writing to an arrestee, in its recent judgment in Vihan Kumar versus State of Haryana, the Honorable Apex Court has minced no words in holding that para 21A, the requirement of informing a person arrested of the grounds of arrest is a mandatory requirement of Article 22(1)B. I'll just read the right. Yes. Para 21B. The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mood and method of communicating must be such that the object of the constitutional safeguard is achieved. We turn the page and we go to para 21C, which says, when arrested person alleges non-compliance with the requirement of Article 22(1), the burden will always be on the investigating agency to prove compliance with the requirement of Article 22(1). The non-compliance with Article 22(1) will be a violation of the fundamental rights of the accused guaranteed by the said article. Moreover, it will amount to a violation of the right to personal liberty guaranteed by Article 21 of the Constitution. Therefore, non-compliance with the requirement of Article 22(1) vitiates the arrest of the accused. Hence, further orders passed by Criminal Court of Remand are also vitiated. Needless to add that it will not vitiate the investigation, charge sheet and trial, but at the same time, filing of a charge sheet will not validate a breach of constitutional mandate made under Article 22(1). E. When an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with Article 22(1) and other mandatory safeguards have been made. And finally, F. When a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail even if statutory restrictions on grant of bail exist. The statutory restrictions do not affect the power of the court to grant bail when the violation of Article 22(1) and 22 of the Constitution is established. Further, Your Lordship, in his concurring opinion, the other honourable judge in the case has in fact expanded on the necessity to communicate the grounds of arrest in writing, not only to the arrestee but in addition also to the relatives and such other persons as may be nominated by the arrestee, so as to enable the arrestee to avail legal remedies and to secure his release from custody. These are the words of the Supreme Court, of course, the highlighted portion on the next page. Hence, the requirement of communicating the grounds of arrest in writing is not only to the accused person, but also to the friends, relatives, or such persons as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution of India meaningful and effective, failing which such arrests may be rendered illegal. Now, this interpretation, Your Honor, Your Lordship,
Yes.
was made by the Honorable Apex Court this very year in Vihan Kumar's judgment. The citation is also quoted, Your Lordship.
This is Oak's judgment.
Yes, Your Lordship. This was passed in the month of February 2025.
Yes.
So basically, it expanded the necessity, and it also said, despite of statutory restrictions, bail would still have to be granted in case of non-communication of grounds of arrest. Lordship, if I may be allowed to read the rest of the remaining paragraphs. Through this, if there's any ambiguity, I'm sure it would be cleared. If Your Honor allows me to read.
Yes.
Para 20. It must be observed that as per the well-settled constitution canon of interpretation, unless the Supreme Court specifically indicates that a decision it renders will operate prospectively, the law declared by the Supreme Court is presumed to have been the law at all times. In light of the above, it must be appreciated that the law in relation to arrests in context of the PMLA declared by the Supreme Court in Pankaj Bansal was held by them to specifically apply henceforth, meaning thereby that the interpretation of the law in that case was to be applied prospectively, which means from the 3rd of October 2023 onwards, Your Lordship. But in Prabir Purkayastha, the Honorable Supreme Court has made no such observation in relation to arrests under the UAP and other criminal offences. As a result, the ratio of Pankaj Bansal would apply to arrests made under the UAP and other criminal offences from the date of pronouncement of Pankaj Bansal, that is the 3rd of October 2023, and not from the date of Prabir Purkayastha, that is 15th of May 2024. Now, this interpretation is also given by the Honorable Apex Court in that judgment itself, Your Lordship. I've already read out para 44 and 45. I'll continue reading. For completeness, it may be mentioned that a contrary view taken by a coordinate bench of this court in Amit Chakrabarti versus State and Prabir Purkayastha versus State has been set aside by the Supreme Court in Prabir Purkayastha itself. This question was raised in paragraph 44-45, which I read, Your Lordship. At the risk of repetition, it may be said that the NIA has argued most strenuously that the requirement for furnishing grounds of arrest in writing was laid down in Pankaj Bansal and Ram Kishore Arora only in the context of section 19 of the PMLA, and that it was only subsequently in Prabir Purkayastha that Supreme Court held that there is no significant difference in the language employed in section 19 of the PMLA and section 43B of the UAP, and only thereafter did the requirement of furnishing the grounds of arrest in writing to an arrestee come into effect under the UAP. Observation is in page 24, para 24, Lordship. The NIA laments that they could not have complied with such requirement in relation to an arrest made under the UAP before the decision was rendered in Prabir Purkayastha. However, in view of the foregoing discussions, this contention raised by the NIA cannot be accepted since the contention stands answered in Prabir Purkayastha itself. I've read out the relevant portions, Your Lordship. Yes. Therefore, there cannot be any two views that the mandate of Pankaj Bansal would not apply to the arrest of the petitioner in the present case, even though they were arrested on the 13th of March 2024. Right, Your Lordship? Right. As noted above, in the present case, it is not disputed that the only manner in which the grounds of arrest were purportedly communicated to the petitioner was by explaining the grounds to them, as noted in entry number 6 of the arrest memo, which can only mean orally. The NIA has nowhere even contended that the grounds of arrest were furnished to the petitioners in writing. Now, we have dealt with this because I read out the arrest memo. Para 27, Your Lordship. Another point raised on behalf of the NIA is that even if the grounds of arrest were not communicated to the petitioner in writing in the arrest memo, such grounds were duly communicated to them in the remand application filed before the learned special court. That is not the case in our case. Yes. This ground is again without merits, inasmuch as a perusal of the remand application would show that what was stated there was only the gamut of allegations against the petitioner collectively, without any specificity or particularization as to what was alleged against each of the individual petitioners, as held by the Honorable Apex Court in Prabir Purkayastha. The difference between reasons of arrest and grounds of arrest is that while reasons of arrest may be generic, the grounds of arrest comprise the basis that impelled an investigating agency to arrest a particular person. Clearly, therefore, what is contained in the remand application also does not meet meet the requirement of communicating the grounds of arrest to each of the petitioners in writing. We have dealt with this, Your Lordship. And finally, just 2 paragraphs left. I'll read the highlighted portion, paragraph 30. Yet again, however, the NIA omits to notice the express observations of the Supreme Court in Prabir Purkayastha, where the court has observed that the mere fact that the charge sheet has been filed would not validate the illegality and unconstitutionality committed by the investigating officer at the time of arresting an accused. Clearly, therefore, any change in the nature of custody or the stage of the matter would not validate an arrest that is ab initio illegal. The NIA must remind itself that the constitutional mandate cannot be circumvented by resorting to jugglery of statutory provisions. These arguments, therefore, also must be rejected. Though the learned counsel appearing for the NIA cited the decision of the Kerala High Court in Sahir EP versus National Investigating Agency, where a division bench of that court had taken the view that any arrest validly made under the UAPA prior to the decision of the Supreme Court in Prabir Purkayastha would not be invalidated merely because the grounds of arrest were not informed to an accused in writing, it transpires that an appeal filed against the judgment has subsequently been allowed by the Supreme Court wide order dated such and such, and the said judgment has accordingly been set aside. The contrary view was set aside. Para 32, it also must be recorded for completeness that in a judgment rendered by Division Bench of the Bombay High Court in Manula M. Kanchawala versus State of Maharashtra, while interpreting the provisions of Section 50 of the CRPC, the court has held that arrests made post Pankaj Bansal were vitiated since they did not comply with the verdict of the Supreme Court in Prabir Purkayastha. The special leave petition challenging Manuwala M. Kanchawala has been dismissed by the Supreme Court in limine. Finally, Your Lordship, in para 33, it says it must be articulated that in light of the verdicts of the Supreme Court in Pankaj Bansal, Prabir Purkayastha and Bihan Kumar, which are founded on Article 22(1) of the Constitution, there remains no doubt that the requirement of serving grounds of arrest in writing to an arrested person is compulsory and unquestionable, regardless of whether an arrest has been made under the PMLA or the UAPA or under any other criminal statute. Observing this, release was given. An order of release was made in this particular case as well, Your Lordship. Your Lordship, thereafter, observing Prabir Purkayastha's, observing the direction given in Prabir Purkayastha's case, bails have also been granted in other cases as well. I'm just giving this to buttress my argument, of course. So this is a case under the NDPS. Not relevant, but I'm just forcing my issue, Your Lordship. In this case, I will not read it, perhaps only read it if required, if a contention is raised accordingly. But in this case as well, it is under the NDPS Act. Because in Prabir Purkayastha's case, what had happened was the Honorable Apex Court held that it is mandatory and incumbent upon the arresting authority to furnish grounds of arrest in writing in cases of UAP and other cases as well. Hence, citing this observation, bail was also granted to a person in NDPS matter as well. And finally, Your Lordship, in a recent observation made again by the Supreme Court in the month of March 2025, it was held, Your Lordship. I'll just read, although the paragraphs have not been numbered. If I may, Your Lordship, the highlighted portion.
So,
we are inclined to consider only the last issue raised by the appellant with respect to non-furnishing of the grounds of arrest. Upon perusing Annexure P, we can see that what has been provided to the appellant is only an arrest memo in the prescribed format, which is meant to be given to the appellant by way of an intimation. It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based upon the statement of the co-accused. Exactly same, Your Lordship. Same situation. We are in agreement with the submission made by the learned senior counsels appearing for the appellant that the said arrest memo cannot be construed as grounds of arrest as no other worthwhile particulars have been furnished to him. This being a clear non-compliance of the mandate under Section 50 of the CRP, under 50 of the Code, which has been introduced to give effect to Article 22(1) of the Constitution of India 1950, we are inclined to set aside the impugned judgment, particularly in light of the judgment rendered by this court reported as Prabir Purkayastha versus State. Actually, why I have actually placed this before you is to show that this particular observation made by the Honorable Apex Court in Prabir Purkayastha has been brought for reference on a couple of occasions. Both times it was dismissed, and still now it is a law of the land. Hence, in all arrests made after the passing of Pankaj Bansal's judgment, 3rd of October 2023, it is mandatory and incumbent upon the arresting authority to furnish grounds of arrest in writing. The accused who has preferred this application was arrested on the 12th of March 2024 after the passing of judgment in Pankaj Bansal's case. Hence, it is applicable to him as well. And we have also dealt with the matter that the restrictions as under the section 43D of the UAP Act would not come in the way of granting him relief of release, Your Lordship. Further, Your Lordship, I pray for his release on 3 accords. First is, of course, non-compliance of the constitutional and statutory mandate of furnishing of grounds of arrest, and 43D, which is the embargo, wouldn't come in the way. Yet, despite of that, Your Lordship, I've also argued, and I've mentioned in the application as well, that there is prima facie no material against the accused as well. Lordship, I'll just take you to certain paragraphs from the petition. I'm ending. I'll just read from paragraph 13, Your Lordship.
Paragraph?
Paragraph 13 of the petition.
Yes.
Para 13. That despite of one of the sections of the UAP Act in the instant case, more specifically section 18, falling under chapter 4 of the UAP Act, thereby attracting the rigors of section 43D of the UAP, compliance of section 43B of or communication of the grounds of arrest to the accused in writing could not have been shunned away with. The grounds of arrest are unique. It's okay. We'll not stress on that. Further, I'll just take you to paragraph 15, Your Lordship. I'm sorry. That a perusal of the charge sheet also shows that there is no evidence against Robinus Ripna. The accused Robinus Ripna was not arrested along with the accused Damanbar Ripna, from whose possession or from whose vehicle the alleged explosives were recovered. It also appears that the only reason as to why Robinus was arrested in the case was because he is related to the accused Damanbar Ripna, and because his number appeared in the phone of Damanbar Ripna. There is prima facie, Your Lordship, no evidence against Robinus Ripna either. Although we have already dealt with that question that even if a prima facie case did exist, because of the non-compliance of the statutory and constitutional mandate, he would still be entitled to release. Despite of that, Your Lordship, when we peruse the record, we find that there is no prima facie case. Even if there was, he would still be entitled to an order of release because of whatever I just read, Your Lordship, the citations which I referred to. And finally, Your Lordship, it is also incumbent upon me to inform the court that the case is still at the stage of framing of charges. He's been in custody for 1 year, 5 months. There are 33 witnesses to be examined. And Your Lordship, it would be gainful for me to take you to finally, paragraph 23. So paragraph 23 of the petition, Your Lordship, I've quoted a line from Athar of Praveen's case. Similarly situated accused, considering to the point of framing of charges not being done, only with regards to that. And in that particular judgment, Your Lordship, in paragraph 32, it was held, if I may be allowed to read, Your Lordship.
Yes.
The appellant was arrested on 12th of July 2022. He has undergone custody for more than 2 years and 4 months. Charge sheet was filed on the 7th of January 2023, but till date charges have not been framed, which is an admitted position. There are 40 accused persons and 354 witnesses cited by the prosecution to be examined. There can be no doubt that the trial is not likely to complete soon, and as has been laid above by various judgments of this court, as has been referred to above, the appellant cannot be allowed to languish in jail indefinitely, and that too without a trial. If such an approach is allowed, Article 21 of the Constitution would stand violated. The ratio as laid down by this court in Union of India versus K. Najib, as also the other judgments in Javed, Ghulam Nabi Sheikh versus State of Maharashtra, and another, and Thwala Fasal versus Union of India, would be applicable to this case and would squarely apply, entitling the appellant for grant of bail. So on 3 accords I've sought for bail, Your Lordship. Firstly, non-compliance of the constitutional and statutory mandate of furnishing the grounds of arrest, and even if the court comes to the conclusion that the rigors are to apply, it would not come in the way of passing an order of release. Secondly, there's no prima facie case against the accused, and thirdly, the charges are yet to be framed. It seems that the trial would be delayed, and in this particular case as well, citing that the charges were not framed for 2 years, bail was granted to an accused. These.
Yes, Mr.
Lordship, I think I'll have to reply, not today, Your Lordship, because so many judgments. I'll go through the judgment, Your Lordship. Can have this matter day after tomorrow.
Tomorrow?
Day after tomorrow, Your Lordship. I'll go through, Your Lordship. Because there are, Lordship, I have seen there is order also by the Supreme Court, Your Lordship, that like in this case, Your Lordship, this Mihir Rajesh Shah also there also, Lordship. It say like this, Your Lordship. I'll have to go through. The question that we are called upon for consent in the present proceeding is whether each and every case, even arising out of offence under the penal code, it would be necessary to furnish ground of arrest to the accused. Lordship. All this, Your Lord. Another also there is, Your Lordship. I'll find out those, Your Lordship. Then I'll place my submission accordingly, Your Lordship. Day after tomorrow, Your Lordship. Day after tomorrow.
Yes, given such an exhaustive argument,
Lordship,
that would
yes.
require you to really,
I'll have to deal, Your
study.
Lordship.
Lordship. So Wednesday, Lord.
When is it?
Wednesday, Your Lord. Apply, Your Lordship.
Heard Mr. S.S. Yadav, Learned Counsel for Petitioner.
Roma.
Argument is concluded from his side. Mr. Indishulai, Learned AG, has sought for some time to reply on the ground that there are certain authorities to be cited which are not available today, which are not available with him today. Accordingly, as prayed for, this is matter for further hearing on referring to
On 20, Your Lordship. 20.
20th.
Apply, Your Lordship.
Highly obliged, Your Lordship. Good evening.
Item number 5.
May it please your lordship. Your lordship, I'm praying for some accommodation in this matter today, your lordship. Learned DSGI is on legs, your lordship.
After 2 weeks, then, Your Lordship. After 2 weeks.
On pre-made by the petitioner, this is matter to 2 weeks.
Apply, Your Lordship.